जब भी हम क्रिमिनल लॉ की बात करते हैं, द फर्स्ट थिंग विच कम्स टू आवर माइंड इज बेल. इट्स अ वेरी इंपॉर्टेंट एस्पेक्ट. हेलो फ्रेंड्स, दिस इज एडवोकेट दीप्ति भगत और आज हम बात करेंगे बेल. बेल क्या होती है, व्हाट आर द टाइप्स ऑफ बेल, व्हाट आर द प्रोसीजर्स, हाउ वी कैन गेट देम फ्रॉम द कोर्ट ऑफ लॉ. फर्स्ट, पुलिस बेल. Section 436 CRPC talks of पुलिस bail. For any bailable offence, कोई भी offence जो bailable in nature है as defined in CRPC, उस offence के लिए अगर हमें पुलिस arrest करती है, we can get that bail either from the police station by applying for the same before the police official or from the court of law also. On that, we can get the bail on a personal bail bond, maybe without sureties also, and this is a matter of right of the accused to get the bail in a bailable offence under section 436 either from police station or from the court of law. Now we have offences which are non-bailable in nature. They are called non-bailable offences. For that, there are two situations. Let's understand. Situation 1. Accused is arrested by the police official. There we go for the bail. That is called regular bail. We have two sections, section 437 and 439 CRPC. Now second situation, wherein the accused is not arrested, or accused को ये apprehension है, or maybe if not an accused, any person जिसे ये apprehension है कि उसके against कोई चार्जशीट रजिस्टर हुई है या कोई कंप्लेंट हुई है किसी पुलिस स्टेशन में, एंड दैट पर्सन इज द एप्रीहेंसिव ऑफ गेटिंग अरेस्टेड एट एनी पॉइंट ऑफ टाइम, दैट पर्सन कैन गो फॉर द बेल टू द कोर्ट ऑफ लॉ. दैट इज कॉल्ड एंटिसिपेटरी बेल. So basically we have two types of bail. One is regular bail and the other is anticipatory bail. Regular bail is covered in section 437 and 439 CRPC. And anticipatory bail is covered in section 438 CRPC. Now let's first understand regular bail. Section 437, it talks of the power of the MM. Section 437 में एक MM हमें bail grant कर सकता है. For what offences? जिनकी punishment is less than 7 years. Meaning thereby, कोई भी ऑफेंस जिसकी पनिशमेंट 7 years और मोर देन 7 years और डेथ पनिशमेंट और एनी क्राइम डन अगेंस्ट ह्यूमन बॉडी और एनी देशद्रोह एलिगेशंस और द पर्सन इज इन्वॉल्व्ड इन इंसॉल्वेंसी एंड कॉन्स्पिरेसी और एनी क्राइम अगेंस्ट प्रॉपर्टी, MM बेल नहीं ग्रांट कर सकता इन सेक्शन 437. MM के ऊपर there are certain restrictions in section 437 CRPC, and the matters, the offences which are punishable for the punishment less than 7 years, accused can get the bail in those circumstances in section 437 CRPC. Now what about the offences which are punishable for a punishment for 7 years or more or death punishment? For that we have section 439 CRPC. It is a special provision, special powers to High Court and Sessions Court. There is no restriction on the High Court or Sessions Court. They can get the bail the accused can get the bail in any sort of matter from Court of Session or High Court in the section 439 CRPC. Maybe the accused is less than 16 years, or if the accused is a woman, or if the accused is ill or infirmed, or any kind of condition which is restricted to the MM in regular bail, can be granted as a regular bail under section 439 CRPC only by Sessions Court or the High Court. Now we must be thinking, how do we get the bail? You have to apply, you have to put an application in the court of law for the bail for the under the concerned sections, and then once the court hears the matter, if the bail is granted by the court of law, then we have to sign a bail bond and we have to give the amount being decided by the court as a condition of the bail to the court of law along with two sureties. But we have to be very careful. हम जब भी bail bond भरते हैं, it is covered in two forms, the upper part and the lower section. The lower section is the muchalka, which is needed in the thana. Even a single spelling mistake in that muchalka will end up making the person being in prison for another one day in spite of having a bail. They do not release the accused from the jail if there is even a single spelling mistake in the name of the accused. ये तो बात थी रेगुलर बेल की. नाउ कम्स द कंडीशन ऑफ एंटिसिपेटरी बेल, जहाँ पे हमें एप्रीहेंशन ऑफ अरेस्ट है. इट इज कवर्ड इन सेक्शन 438 CRPC, and any person who is having the apprehension of arrest regarding any complaint made against him in any thana or any FIR registered against him or any sort of apprehension, that person can approach the court of law, but only to court of session or high court, because this power is not given to MM to grant anticipatory bail to the accused person. And again the procedure is same. You have to file an application in the court of law and put your circumstances before the court, and if you get the bail, again the same thing. You have to sign a bail bond, you have to give two sureties to the court, and you have to pay the amount as being directed by the court of law as a condition to the bail. Now when we were talking of section 436 of police bail, there was an amendment of section 436A which says if the accused has already spent half time of the maximum punishment for the offence being charged against him, meaning thereby जिस offence के लिए accused booked है, उस offence का जो maximum punishment in the court, in the law, books of law है, उसका अगर half tenure accused already jail में बिता चुका है, have already spent it in the prison, that person, that accused should be released on bail, but that is a temporary relief and the trial continues against the accused, and if at the end he is proved guilty and more punishment is needed, he might have to go under the jail once again. Let's take an example. किसी accused ने कोई ऐसा offence किया है, suppose जिसकी maximum punishment 3 years है. Trial is going on, investigation is going on, charge sheet may or may not be filed, and the accused has already spent 1.5 years in the jail. Now, as a matter of right, that person should be released on bail till he is proved or not proved guilty in the same matter. ये तो बात थी रेगुलर बेल सेक्शन 436 पुलिस बेल, रेगुलर बेल सेक्शन 437 439 CRPC, एंटिसिपेटरी बेल सेक्शन 438 CRPC, section 436A which talks of half tenure already spent in the jail. There is one more type of bail, default bail. What says that? Section 167 CRPC talks of default bail. Once the FIR is booked against an accused, the investigation starts. Suppose the person is arrested, already in jail. The time period for the police official to complete the investigation is 60 days or 90 days in total. If the charge sheet is not filed by the police officials either in 60 days, in the cases wherein the punishment is less than or equal to 10 years, and 90 days for the matters wherein the punishment is more than 10 years or death imprisonment. In such circumstances, if the charge sheet is not filed within 60 days or 90 days, it is the matter of right. It is by default becomes the matter of right of the accused person to be released on bail, but it doesn't become the right to be released on bail without filing the bail application. The accused has to file a bail application in the court of law, being ready to fulfill the terms of the bail and being ready to give the amount of the bail and two sureties along with it. It becomes a matter of right of the person to be released on bail. This is under section 167 CRPC default bail. जिस भी circumstance में if the charge sheet नहीं फाइल हुई है 60 दिन में या 90 दिन में, 60 दिन में उन केसेस के लिए जिनकी पनिशमेंट लेस देन 10 ईयर्स है और इक्वल टू 10 ईयर्स है, 90 दिन उन केसेस के लिए जिसमें पनिशमेंट मोर देन 10 ईयर्स है और लाइफ इम्प्रिजनमेंट है और डेथ इम्प्रिजनमेंट है, डेथ पेनल्टी है, उन केसेस में 90 days. It becomes a matter of right of the accused to be released on bail after filing the bail application and fulfilling the conditions of the bail. So friends, अगर मेरा ये वीडियो अच्छा लगा हो, if it is informative to you, please press the subscribe icon and like my video and share it further. Thank you. Have a nice day.